we're going to get started pretty quick here. Right at 10 o'clock, we're going to get started.
I know it says that you're recording. Are we going to get a recording of this? Or are they just recording it for you guys to have?
Oh no, Cindy, I'm going to post it to my YouTube channel, and I'll send out a link to the video to everybody on the call. And I'll also send out my highlighted slides or my highlighted contracts. You have my notes.
Yay! I like listening, but I can't drive and watch.
Please don't drive and watch. Please drive and listen.
I made my Cape Coral VA appointment at 7:30 this morning. I thought I'd be back in time, but it just doesn't work.
Right. And everybody, as typical, we're going to start right here in about 1 minute. But if you have questions or things that you want to know specifically about the contract as we're going through it, you should always feel free to shout it out. Or put your questions in the chat. I'll be monitoring the chat as we go through this. And if you'll mute yourself, I'll see that, and we'll get your questions answered. And I'll stay as long as needed to get all the questions answered at the end as well. All right, everybody, it's 10 o'clock. Let's get started. Today, we're going to be talking about the FAR bar contract. I'm going to go ahead and share my screen. So hopefully everyone can see that. Shake your heads. You can't. You can see that. Good. All righty. So because I am an attorney, we're going to start off with the disclaimer as we talk about the FAR bar contract today. I'm going to go through the contract. I'm going to talk to you about all the various facets of the provisions of the contract, but it's not officially legal advice. And if you have specific questions for yourself or your customers, you can always email or call me separately. A little bit about my firm. We were founded in 2007, and we focus on real estate and business law. I help realtors, small business owners, entrepreneurs, buyers, sellers, property managers, pretty much everything that touches the land. And we have a full service litigation department, so we can handle deposit disputes, landlord-tenant actions, contract disputes, all types of things in your business that will be helpful to you. And we have offices throughout Southwest Florida, although we do service the entire state. I have been an attorney since 2003, and I specialize in real estate law. I serve on the NABOR Legal Resources Committee, which drafts the NABOR contract, and I serve on the reptile section of the Florida Bar, which drafts the FAR bar contract. So I will be doing some compare and contrast for those of you in the Southwest Florida market that know NABOR. You'll hear me talk about the differences a little bit for those of you across the state. We're going to be talking about FAR bar version 6 today. And that's the newest version that just came out with the changes to the financing contingency to take away the appraisal contingency. We'll talk about all that as we go through it. Before I get started, does anybody have any quick questions? Okay, seeing none, we're going to dive right into this contract. And oops, move that off my screen. Okay, so this is the Florida Bar, Florida Realtors contract. It's approved by the Florida Realtors and the Florida Bar in a joint committee. It's vetted by several groups. I serve on the Real Estate Industry Liaison Committee of the Florida Bar, and that's one of the main groups that reviews this contract. And to start off, we're going to talk about the parties to the contract. So right here at the very top of the contract, you've got your seller information. Typically, sellers are the harder party to figure out who to put on here. If it's husband and wife, or if it's individual, then you put their name in this block. If it's an LLC, you put the name of the LLC followed by the word LLC. And then, of course, you have to figure out who's going to sign for the LLC. And I do a whole separate class on that. But basically, you need to look at the operating agreement or the articles of organization for your LLC to determine who signs. If you've got a trust, you've got to review the trust agreement. And of course, LLC operating agreements and trust agreements get pretty complicated pretty quickly. So you should probably contact your favorite closing attorney and get some information as to who's going to be the seller when it's not the individual. Of course, the buyer is easy. You put your client's name in there. If they're going to take an assignment to an LLC or to something else, you do not need to write the word or assigns in this blank, in the buyer blank, because there's a space below that we're going to talk about for assigning the contract. The FAR contract is pretty comprehensive in the way you describe the property. You put your street address, city, state, zip in the first blank here, what county the property is located in. Please don't skip the county blank. I see this occasionally. People forget to put which county it is, and we have some neighborhood associations that are the same name in multiple counties, and we don't want to screw that up. And then you got your tax ID number for the property. Get that from the tax collector or the property appraiser. It's the property identification number. And then your legal description goes here. The legal description, you can use the short legal off of the property appraiser's website, although I will caution you, if you've got a large meets and bounds legal description, I would put C attached and then copy the legal description from the prior deed. And usually there's an exhibit A or a prior deed that's got the legal on it, and you can just use that exhibit A. Oops, okay. This contract is a little different than the NABOR contract. It does not spell out what fixtures specifically transfer. It just generally says fixtures, including built-in appliances, built-in furnishings, and attached wall-to-wall carpeting and flooring. And that's how they describe the real property. Why is this important? If it's screwed or glued, it's a fixture and it stays. So the ceiling fans, that favorite chandelier in the living room or in the foyer, all of those are fixtures that stay unless you specifically exclude them down here in section E. And you write in foyer chandelier in this blank. Otherwise, that chandelier is going to stay. That favorite fixture that was given to somebody by their grandmother, you want to make sure that that's going to, and I mentioned that because I have this case. You want to make sure that you specifically exclude it or the buyer's going to get it. This contract also talks about the personal property that transfers. You've got your ranges, your ovens, refrigerators, dishwashers, all the things listed here. Note that the washer and dryer are not listed. So for those of you in Southwest Florida that are familiar with the NABOR contract and familiar with the washer and dryer transferring, know that it does not transfer under this contract. If you wish to transfer the washer and dryer, you need to write it in here, washer and dryer, or other appliances that are not specifically listed that you may want to transfer. Note, oops, they have included other access devices, mailbox keys, security gate, and other access devices. So you would transfer all those items. This contract does not specifically include like smart home components, but again, if it's screwed or glued, it stays. So the television racks, the wall mounts for the television would stay, but if the TV can be lifted off and carried away, then you could take your television. Like the other contracts, this is for the lenders here. There's no contributory value to the personal property. It conveys at no value. So if you've got one of those situations where the buyer is getting a loan and the seller wants to sell as opposed to give the personal property or the furniture or anything else that's going to stay with the property, then you would need to do a separate personal property sales contract, which I can provide you that form. It's not a form provided by the Florida Realtors or the Florida Bar, but I have created a form that you can use to transfer personal property for value separate from the contract. So keep you out of trouble with your lenders. Questions about the property and what we're actually going to be selling? Okay, you can always put your questions in the chat as well. So up next, we're going to talk about the purchase price. You put your purchase price up here. You put your initial deposit here, and then you fill in whether it's going to be made within so many days or accompany the offer. Typically, it's 3 days after the offer is made, the first deposit is due, and that's to accommodate weekends and holidays and wiring money. I did have a situation just this Labor Day weekend where they wrote in 2 days in this blank right here. And then the buyer was confused because he didn't realize that Monday didn't count. And so we had a little situation with getting a late deposit. So pay attention to this number. If you've got a holiday or if you need extra days for your buyer to get their wire organized, you're going to want to give time in this blank right here. We did have a question about the microwave. It's not listed. So if it's a built-in microwave, it's a built-in appliance. If it's not built in and you want to leave the microwave, you would write it here on the net. Okay. So going back to the purchase price and the escrow. So Florida regulations require you to identify the escrow agent on the contract by name, address, phone number, email, and fax. So don't skip this blank or put TBD. Have a conversation when you're making your offer with your listing agent and make sure you get this filled in so you stay in compliance with Florida regulations. If there's going to be an additional deposit as to when it's due, you fill in that blank here. And then of course, put your amount here. Typically, now I will say this about the deposits, they have got to be collected funds. And we're going to talk about collected funds. It's noted here in section E. Collected funds, you can basically mean they've got to wire it in. The initial deposit could be by check, but the second deposit, especially if it's close to closing, and the final proceeds to close need to be wired in. You could do an ACH, but that has complications for most closing agents. Just plan on telling your buyers they've got to send their wire in. Rich is asking, is 3 days inclusive of holidays? It's 3 calendar days, Rich and Daisy, but if any deadline in this contract falls on a weekend or holiday, it rolls to the next business day, and they have until 11:59 at night to get the money in on the next business day. So again, using Labor Day, which we just had the Labor Day holiday, all of you that wrote contracts on Friday, Saturday, and Sunday and said 1 or 2 days to get your deposit in was due yesterday or today. So it rolls to the next business day. And again, collected funds, there's a new standard S that's been revised in this version of the contract to talk about collected funds. And when we get to standard S, I'll get into more detail about that. One thing I do want to mention, make sure if you're looking at a FARBAR form, if you've pulled it up, make sure you're looking at form version 6, the newest version, version 6. We want to make sure that everybody's looking at the same form, because as we get into some parts of this, it's going to be, you want to make sure you are not looking at the old form. So let's talk about time for acceptance of offer and counter offers and the effective date. In this contract, the contract is not effective until it is fully executed and delivered to both parties. So you can see here, it says the effective date of this contract shall be the date when the last one of the buyer and seller has signed or initialed and delivered this offer or final counteroffer. What does that mean? Well, in practical terms, if you're negotiating an offer and it's 10 o'clock at night and you finally got everybody to agree and you send the last counteroffer to the seller to sign, and the seller goes to bed without sending it back to you signed, then they may have signed it today, but if they don't deliver it back to the buyer tomorrow, until tomorrow, then tomorrow is the effective date, even though all the dates in your DocuSign say today. So it's not enough in the FAR contract to look at the face of the document and say, okay, the last date signed and initialed was today. We have to look and see when it was delivered. And that requires realtors to coordinate with each other and communicate with each other so that you get an email back, hopefully from the buyer's realtor that says, thank you, received, so you know it's been delivered. This comes up when you're trying to negotiate a short inspection period. Is it 7 days from today or 7 days from tomorrow? And we'll talk about how that works. Again, when we get to the time periods at the end here, but make sure that you deliver the contract. Don't just sit on it overnight. Closing. So this is a change to this contract that I really like. They have actually defined closing in this contract. And it says the closing of this transaction shall occur when all funds required for closing are received by the closing agent and collected pursuant to Standard S, and all closing documents required to be furnished by each party are delivered. That's the closing. I love that they actually define closing in this contract. I wish it was a little bit more definite as to what's going to happen, but it's good enough. It's a good start. It's something that the NABOR contract does not have. And we need to work on that in NABOR. But the closing occurs when all funds required for closing are received and collected and all the documents are into escrow. So when the closing agent has everything, we're ready to close, which you would think would be just known, but writing it down so everyone is on the same page is, in my opinion, a very good thing. Giaconda is asking if the owner is a trust and we list the trust name, you would list the trust name up here, Giaconda, right here as the seller. So you would put the name, you would put Bob Smith as trustee of the Bob Smith Trust. Okay. So when can the closing date be extended in this contract, and how and under what terms can the closing date be extended? Well, there are two provisions here that talk about extending the closing date. One is for CFPB requirements. CFPB is the Consumer Financial Protection Bureau. That's a federal government agency that manages the RESPA and the Truth in Lending Act and some other things, basically governs closings. And what this says is it creates a three-part test as to when you can extend the closing when you have financing. Number one, the funds from the buyer's lender are not available on the closing date one, due to Consumer Financial Protection Bureau closing delivery requirements. If 8B is checked, that means that there's financing. You also have to have loan approval, and lender's underwriting has to be complete. So you have to have financing, you have to have loan approval, and underwriting has to be complete, or this extension provision does not kick in. What does that mean? If you are working with your buyer's lender and everything looks like it's on track for a closing, but the underwriting is not complete, the buyer's got to get one more piece of paper into the lender to be examined, or something is not quite done with underwriting examination of the buyer or the property, then this provision would not kick in, and you would not get the additional 7 days. You would not get the additional 7 days for satisfying CFPB requirements. And remember, in this contract, time is of the essence for closing and for all dates. So if you miss the closing date and you don't have a proper extension, the buyer's deposit is at risk. So it's very important to meet this three-part test to get your 7-day extension. The other way that you can extend the contract is through force majeure. Force majeure is the hurricanes and other things that we get to deal with down here in Florida, weather events, hazards that we're going to talk about. We get to the force majeure clause, but that can extend the contract as well as provided in standard G, which we're going to get to in a little while. Okay, Doug is asking the question about on or before for the closing date. So what does it mean when someone has written on or before a specific date in this blank for closing? What it means is that you close on that date listed unless the parties agree to a different date. So the fact that you have written on or before, I see buyers will say, I'll close on or before September 15th, depending on when my funds are available, for example, for a 1031 exchange, or when my inspections are completed. I'll close on or before. Well, if the seller, for whatever reason, is not ready on the date that you want to close, you don't get a close until the date listed in this blank, even if it says on or before. So you still have to agree with, to a closing date regardless. Okay, let's talk about occupancy and possession of the property. The seller is obligated to deliver occupancy and possession that's free of tenants, occupants, and future tenancies at closing. That means that the tenants have to be out, you have to be out if you're the seller, and the property's got to be ready to be moved into by the buyer. Also, in this contract, the seller needs to remove all personal items and trash. So in NABOR, it has to be free of debris and broom clean. In FARBAR, you remove all personal items and trash. So does that mean I had the case where there was a pile of bricks left on the back of a piece of a large estates lot, and the buyer claimed it was debris? If it's not trash and it's been there for years, then it's likely that the seller is going to be able to leave it under this contract. Notice that the seller shall deliver. Yes, Cindy. Go ahead.
On the tenants, if you're selling a property that has tenants in it with a lease, can you address?
Oh, you cut out.
Property that has tenants in it that have a lease, can you address how that is affected?
I'm gonna get to that in 1 second. That's paragraph 6B, and I will talk a lot about tenants in about 2 seconds. Real quick though, about just regular, if you don't have tenants, the property, you need to deliver all keys, garage door openers, access devices, and codes to the buyer at closing. Notice it says at closing. So what does that mean? We always get into these disputes. The seller won't release keys until they get their money. There's no contract in Florida that I've seen where the seller gets to hold up the keys until they get their money. That would be a breach of contract by the seller for failing to deliver all keys, garage door openers, access devices, and codes as applicable at closing. Disbursement of the money occurs immediately after closing. And the reason it is that way is because if we close at 6 o'clock at night and we can't get wires out, the seller is entitled to come get a check from my office or wait until the next business day to get their wire. But that does not delay closing. Once I have the money as the closing agent and I've got the documents from the seller, we're going to close. I'm going to record the deed and I'm going to deliver the money. But the seller doesn't get to hold up the keys until they get their money, and that can be a major bone of contention for folks. I know I deal with that quite a bit.
Sam, I have a question.
Yes, Tina.
If you are closing tomorrow and the buyer want to put a golf cart they bought tomorrow, you just mentioned that there is no law that you cannot give them a code for garage, perhaps, or something, right?
You could do a pre-closing occupancy. This happens quite a bit. And you could do a simple pre-closing occupancy agreement. FARBAR does not provide that form, but I can create it for you very simply. Yeah. And you could say, and I've done this many, many times, where you would just say, buyer shall have access to the garage only for purposes of parking a golf cart until closing. And you could even
Okay.
say, if you want to be more cautious, you could say, if closing does not occur, buyer shall be entitled to retrieve the golf cart. So you can do things like that with a special addendum.
Yeah,
Or
but it
addendum.
can also create a problem, say for any unknown reason, you don't close at all.
That's why
And
you
now-
want to protect your buyer in the document. That's right.
Right, but then they will say, well, they're not picking up because they may close next month or something like that. Then the seller, if you're representing the seller, they are in a big dilemma, even with that addendum or amendment, you know?
Well, if you have a properly drafted amendment, there shouldn't be a dilemma. What you
Okay.
run into, when you do it, if you do it correctly, I've got a fairly comprehensive form that I use that covers these things.
Okay, perfect, thank you.
Sure. Okay. Okay, leasing. So if the property is leased, then you would check this box here. Oops. Check this box right here. And this property is subject to lease or occupancy after closing. And then if there is a lease, then it's basically 5 days to review, to get the lease to the buyer. The buyer has 5 days to review the lease and reject the terms of the lease and terminate, get their deposit back. One nice thing about this contract, we do not do a tenant estoppel for seasonal rentals or short-term vacation rentals. That saves the seller a lot of aggravation having to go back to all their tenants if they're selling a vacation rental, a VRBO. And I could do a whole class on how to deal with VRBOs. So they're very, very difficult to deal with the Airbnbs and the VRBOs. Okay, any questions on occupancy and possession or extension of the closing date or closing questions before we move on? Okay, seeing none. Assignability. So I mentioned this earlier, but this contract has got a provision here that says the buyer may assign and thereby be released. The buyer may assign but not be released, or may not assign this contract. Note that the seller doesn't get to assign the contract because they are the deeded owner of the property. They can't sell the property to somebody else who then sells it to your buyer. At least it can be done, but not using this form. If no box is checked, then the buyer may not assign this contract. Note, this is a pretty big change from Florida's default rule. If this sentence that I'm highlighting right now was not in this contract would be freely assignable, but the buyer would not be released from liability if there was no box check. So this changes Florida's default to say the buyer cannot assign the contract. And that is a big deal because you want contracts to be assignable, especially if you're going to put it into an LLC or a trust. So make sure you note what your buyer's plans are for titling as soon as possible and check the appropriate box.
Sam, Bob has a question about tenant leases.
Mm-hmm. Yes, Bob.
If the, on a short-term lease, if the lease has that the seller can cancel the lease by giving the renter a 90-day notice, would that be a big problem if in the short-term rental lease, there's a clause that says the owner can give the tenant a 90-day notice and cancel the lease?
Would it be a problem if there was a 90-day cancellation clause in the lease? I don't think so. Because again, the buyer would have the opportunity to review the lease and know that within 10 days of the effective date to get, assuming the lease was properly delivered for review. I actually like a provision like that in a short-term rental agreement because one of the major problems with short-term rentals is the VRBOs and Airbnbs of the world don't have mechanisms for transferring the property. So, or transferring the rentals. So if you're a seller with 5, 6, or 10 short-term rentals over the next season, and you sell the property, you basically, what VRBO and Airbnb tell you to do is cancel all your leases and have the buyer rebook. which can be very frustrating for buyers and sellers who are buying investment property and they want that rental income. So hopefully they'll resolve, the services will resolve that problem in the future. And I will talk about, I've got a writer that talks about management companies that we can get into for leases as well later. But it can be a real issue with these short-term rentals. So a 90-day termination might be a good thing if the seller can terminate their rentals and then rebook them in the name of the buyer through the service, the VRBO or the Airbnb. All right, let's talk about financing. So major overhaul of the financing provisions of this contract. So I'm going to take a few minutes and go through this in some detail because you don't want to think you have an appraisal contingency, for example, and not have an appraisal contingency because they took it out. So when you're dealing with cash and no finance contingency, very simply, the contract says this is a cash transaction with no finance contingency. Now, later on in the contract, you're going to see that the seller needs to get access for appraisers and surveyors and other folks to get the property inspected and reviewed. So just because you have checked box A and there is no finance contingency does not mean that you can't get financing and get an appraisal. It just means that if you don't get financing and you needed financing, your buyer is going to be out their deposit, among other things. So let's say that you did need financing, you checked box B here. This contract is contingent within up to 30 days or however many days you put in here. I actually would put more than 30 days in this blank. I would go with underwriting being the way it is right now, at least 30 days, maybe more, to get that's your loan approval period. And what you're trying to get is loan approval. Loan approval is defined in this contract. I'll get to that in a second, but let's go through the terms that they want you to fill in here. And you've got to be specific when you fill in the terms on this contract, because there's some bad case law out there, which you've been in my classes before. You've heard me talk about the Lafont decision, which basically says if the buyer changes their loan, say from conventional to FHA, then they are not in compliance with getting loan approval, and they don't get a finance contingency and they can lose their deposit. So if you do switch loan products in the middle of your contract, you need to do a contract amendment. That's very important under the Lafont decision. If I'm an unscrupulous seller and I want to nail the buyer and because they can't get financing on what they applied for or at the interest rate that they applied for, then there can be some real issues for your buyer's deposit if we don't get an amendment. And the nice thing about this contract is essentially the buyer can terminate within their loan approval period at any time, as long as they've exercised good faith and diligent effort to obtain loan approval. So walking through this form, the buyer picks the type of loan they're going to get, FHA, VA, conventional, or other. They pick whether it's going to be fixed or adjustable, or whether they could go either way on their interest rate. They pick their interest rate amount. If you leave this blank, then it's based on the prevailing rate for the buyer's creditworthiness. So in the NABOR contract, this is not here, and if you leave it blank, we have a problem. In this contract, if you leave it blank, then you go to market rates, and that can be pretty tough for a buyer if they expected to get a loan at 5% and their interest rate comes in at 6%. Susie is asking if you're going to do an amendment. Yes, Susie, you would need to amend within the loan approval period. So you, the other part of this loan approval here is, see where I highlighted and buyer's mortgage broker or lender will receive an appraisal of the property satisfactory to the lender. So now in this FARBAR contract, you have to get loan approval and an appraisal within the loan approval period. And that means you have to get the appraisal done early. Buyers don't like this because they have to pay for the appraisal before the inspection period is up, but you don't have a choice anymore in FARBAR. You must get your appraisal done in the loan approval period, which is typically the first 30 days. You can't wait till the end anymore. Does everybody understand that? You can't wait to the end to get your appraisal. So tell your buyers to tell their lenders to get the appraisal ordered. So we have another question. What if after the 30-day period and within 30 days of closing, the buyer's financing changes? And for example, a 1031, you would be, if you were outside the loan approval period, Susie, your buyer's deposit's at risk. So if the changes and you don't get the seller to agree to the change, the deposit is at risk in this contract. It's very strict. Okay, so the buyer must use good faith and diligent effort to obtain loan approval during the loan approval period. And if you don't, it's a default. The buyer's got to provide all the documents to the lender, all the pay stubs, the tax returns, the W-2s. If they're an independent person like a realtor, they're going to be providing financial statements for multiple years. If they've got multiple other properties, they're going to provide information on those. And they must do that because right here it says the diligent effort includes timely furnishing all documents and information required by the lender and paying all the fees and charges. So your buyer's going to have to be proactive and upfront now to get their loan approved. They can't wait till after the inspections are done. In this contract, the loan broker keeps the buyer and seller's realtors fully informed about the status of the loan. That's a nice note for the sellers who want to know what's going on. They can call the mortgage broker and ask. Megan is asking, can you expand on the risk of changing from conventional to VA without financing? When you say addendum, referring to the VA? No, Megan, what I'm saying is if you go from conventional to VA financing, you need to amend the contract to check the correct box here where I'm highlighting. You have to check the correct box. And if you change boxes, you need to do an amendment to contract. Okay, moving through this financing contingency a little more. Bob, I'll answer the Namor question in a second. Moving through this financing contingency a little bit more. If within the loan approval period, the buyer obtains loan approval, so within the 30 days or within the 45 days, whatever you put for your loan approval period, if you get approval, the buyer shall notify the seller. So if you do get approval, you must tell the seller of that prior to the expiration of the loan approval period. If you're unable to obtain loan approval, but the buyer wants to proceed with closing, then the buyer shall deliver written notice confirming that prior to the expiration of the loan approval period. If the buyer is unable to obtain loan approval, or they cannot meet the terms of the loan approval that they get, and you're still within the loan approval period, then the buyer can terminate the contract and get their deposit back. If the buyer fails to deliver one of those notices, either terminating the contract or saying I have loan approval, I'm proceeding to closing, and the loan approval period expires, then the seller gets to move forward and they get 3 days to examine and make a decision whether they want to move forward or whether they want to terminate, return the deposit, and put the property back on the market. And that's only if the buyer is not in default of the contract. So if your buyer is in default and the loan approval period expires, then the seller can argue for the deposit. Do I hear a question? Going back, James asked, can you check all these boxes up here? You could, it says check one, and I wouldn't check all of them because it creates confusion. What I would do to resolve this problem, that the new issue that this contract creates with loan approval, I would get with your buyer and get with their lender before you go to contract and get some type of pre-approval that's more than one of those internet letters. Talk to a lender, a person at the loan office, the lender, and say, what can my buyer get approved for? What are their options? And then pick the best option and then go to contract. So you get a little, you got to do some legwork up front with the lender now before going to contract. It shifts the issue up front, the loan issues up front, instead of dealing with them like after the inspections. And then Bob asked, how does lender's appraisal affect the neighbor contract when it comes in low? Bob, the neighbor contract is a totally different financing scheme. I'm not going to get into it here because we're talking about FAR-BAR, but just know it's completely different in the way that it manages financing. And I go through that in detail in my neighbor class. So if the loan approval date expires, the buyer doesn't exercise either option, the seller can cancel within 3 days and return the deposit. That's right, Rebecca. If the buyer does not get their financing approval and they do not terminate within the loan approval period, it kicks over to the seller, who has 3 days to terminate at the end of the loan approval period. Okay, if the buyer has timely provided notice and then fails to close for whatever reason, the deposit goes to the seller unless there is a property related condition that has not been met or otherwise waived. So now how I read this, and this is very important, what happens if you're selling a condo and you're on Marco, for example, or you're any place where you're selling a condo, and the condominium association doesn't want to fill out the new Fannie Mae Freddie Mac condo questionnaire that talks about the structural integrity of the building. As we all know, the Surfside disaster happened, and there's been some major revisions to the law in that regard. But what happens if it's on the seller's side that certain conditions have not been met? Well, in that case, the buyer gets their deposit back and the contract terminates. So you've got to be careful here with this on the seller side to make sure that your associations are timely getting information to the lenders. Okay. We have a question. What if the buyer wants to move forward? Batia, the buyer can always move forward just with cash, or get a private lender, or just get it done by the closing date. You can always move forward.
So but if can you hear me?
Sure, Batia, go ahead.
If the buyer, so my question is, the buyer is their financial loan period, and they want to move forward. Is that the seller still has that option to cancel within 3 days of the expiration?
No. The buyer, prior to the expiration of the period, the buyer can waive the contingency and lock the seller in. But you got to do it prior to the end of the loan approval period.
Let's say he says they want to move forward, but the seller's like, I don't want, even though the buyer wants to move forward.
Well, the seller does not have a termination option unless the buyer let the loan approval period expire without waiving it. So say you've got a 30-day loan approval period, and it's day 30, and the loan's not going to go through, but the buyer has the cash and wants to close. The buyer just waives the contingency. Just send a written notice to the seller. I, buyer, hereby waive the finance contingency in my contract, and that locks the seller in. If you're in a 30-day loan approval period and day 31 comes around and the buyer hasn't done anything yet, then the seller gets their 3 days.
Okay, so they must do it, they must have a financial obligation of the loan within the 30 days, as long as they know the seller
You're breaking
cannot
up.
cancel.
Right. That's
Okay.
right. You're breaking up, but
Thank
I
you.
think you've got it. Yes.
Okay,
Other questions about financing before I move on? I know it's complicated. I know there's a lot in there. Feel free to shout them out or put them in the chat. And if you think of something later, I can always come back to it. So the next two options for financing are the assumption of existing mortgages. I actually suspect that we may see more of this now that rates are going up, at least people trying to assume mortgages. I don't think that lenders are going to allow it, but it is an option. And then, of course, you have your seller financing, where you would use Rider C and do seller financing. I will say this about seller financing. If you do seller financing, please call me, because if this gets screwed up and we can't make the note and mortgage match what the terms are in the seller financing, we're going to have a problem. We're going to have to do an amendment to contract. So just when you've got seller financing as an option, just call me up front and we'll talk about it and make sure it's done correctly. Okay, one last call for financing questions. Okay. Okay, closing costs, fees, and charges. So this contract, we're in the FAR bar regular contract, not the as-is contract. And what we're going to do is go through this Section 9 financing, and then when I get to the repair item, Section 12, I'll talk more about that. But just know this contract lists out the cost to be paid by the seller, including the title charges. If you've got the seller paying for title, then the seller is going to pay for the closing, owner's policy, and charges. So there are some class action lawsuits out there where title companies under the FAR bar contract try to charge the buyer a closing fee when the seller is paying for title. And those look like they're going to be pretty bad for the title companies that do that. We don't do that in my office. We only charge the party that agrees to pay for things. And notice this is not a big deal for you as the realtor. It's more my problem as the closing agent, but the municipal lien search is paid for by the party that pays for the title insurance policy. And that's like $117. The other thing the seller pays for, this is the big one, the seller pays for the repairs under the general repair limit, the WDO limit, and the permit limit. Note here, the default is 1.5% of the purchase price. So you could have up to 4.5% of the purchase price available to the buyer for repairs if there are repair issues under general WDO and permitting. This can be a lot of money. If you've got the listing, you want to limit this amount as much as possible. So make sure that you're paying attention to your repair limits and you put the appropriate either dollar amount or percent of the purchase price here. If I have the seller, I'm going to want this to be as low as possible. If I have the buyer, I want these numbers to be as high as possible. So just know that when you're going back and forth, that's what you're arguing over. And excuse me, this is your permit limit. These three items together, and those are seller expenses. Now,
Sam,
yes, Tina. Yes, Tina.
what is customary that if you are on a seller side, that they put a dollar amount? What is approximate? Say it's a $500,000 property. What is approximate amount that you see most often? That
I
they
typically see this left blank and leave it at 1.5%.
Okay.
I never recommend that for larger properties. So if you've got a $500,000 property,
Yes.
I'm not very good at math, but if I've got a $500,000 property, what is that?
About $7,000. About $7,000 on 1.5%.
Yeah, $7,500. So think about
Right.
that.
Mhm.
You can get a lot done for repairs for $7,500.
Yes. But if you're
Whereas-
representing the seller, can you put down 4,000 on instead
Sure.
of?
Absolutely.
Okay. And then if you're representing the buyer, otherwise you leave it alone at 1.5. Which is the
I
highest.
would do exactly that, yes.
Okay, okay. Thank you, Sam.
You're very welcome. And just remember, think about that on a $500,000 property, if you've
Right.
got $7,500 for each of these, that's over $22,500 that's available for repairs. But remember, it's specific to each set type of repair. You have your permit limit, your WDO limit, and your general limit, and they're different. And when I get to section 12, there are different standards. Now, what happens if the repairs are not done, the WDO was not done, or the permits are not done? If the seller is unable to meet the maintenance requirement, or they have not completed the repairs, then you escrow 125% of the estimated repair cost to complete the items, but not in excess of the 1.5% or whatever your limit is. So you got to do some math and work with your escrow agent to make sure you get the right money into escrow. And then of
Quick
course,
question on that, Sam.
Yes, Cindy.
So septic tanks come in here. The septic tank replacement is quite expensive and it generally doesn't fit in the 1.5%. But if the sellers don't disclose anything and my buyer's inspection pulls up a septic tank problem, and this is the contract we use and we had the limit in there, can we still move forward if they agree to change that amount?
Sure, you can always agree to move forward. You can always come up with an amendment. You'll want to get me involved or your favorite attorney involved to draft it so that you're not practicing law without a license. But you can always do an amendment for septic. I'll double check here when we get into section 12 about the specific repair items. I believe septic is one of the general repair items, and if it's going to be a $10,000, new septic tank or whatever it is, and it's over the general repair limit, then there's a process you go through in the contract for dealing with that, short of doing an amendment. So you always can do an amendment. You can always renegotiate, retrade the deal, whatever you want to call it, if you find things in the inspection process that were unexpected on either side. You understand that?
Yep, because the septic tank is not cheap and rarely known until it's inspected.
Correct. And sellers usually don't know because they don't think to get their septic tanks inspected. That's actually a pro tip. If you've got a property with a septic tank and your seller is getting ready to list with you, you might suggest, hey, when's the last time you looked at your septic tank? Can we spend a few dollars and get an inspection so we don't get surprised later? That's probably a good money well spent. Okay, so the next section here, the section B of section 9, sub B, talks about the buyer's costs. Very similar. They pay for the title policy. They pay for the charges. Now the difference is sellers have duties to provide documents, and sometimes the seller is going to pay an attorney's fee even when the buyer pays for the owner's policy, and that's something that's going to have to be worked out on a case-by-case basis depending on the type of work that has to be done in the property. Yes, Giacondo, I'm recording this. Okay, so then you get into title evidence. I don't spend a lot of time on this. This is mostly for me, but basically I've got to get the title policy, the title evidence ordered and cleared. The seller's got to deliver their prior policy. This is where you pick right here. We're in section 9C. This is where you pick who pays for title and closing. Either the seller pays, the buyer pays, or for those of you in Miami and Broward, then the buyer pays for title, but the seller pays for the title search. It's kind of how that shakes out. The survey, at least 5 days prior to closing, the closing date. This is a big deal. You could have an extension of contract if 6 days prior to closing, the survey comes in and there's an encroachment and the buyer sends a letter to the seller saying, hey, you got encroachment, they've got to be fixed, then you could have an extension under the title defects provision of the contract that we're going to get to. But just know that you may not know that until 5 days prior to closing. If the seller has their own survey, then they have 5 days from the effective date to get that survey to the buyer so they can examine and determine if they want to get their own survey. This gets skipped all the time and it drives me crazy. If you are getting a home warranty or not, check the appropriate box for the home warranty. At closing, either the buyer, the seller, or no one is going to pay for a home warranty, and there's going to be an amount listed here. Please don't skip that box, because then it just creates a lot of confusion as to whether a home warranty was to be provided or not. Okay, special assessments. This is not condominium assessments. This is not HOA assessments. This is public body assessments. Those would be your Cape Coral improvements, sewer improvements, Marco sewer improvements, other special assessments produced by a public body. Those have to be certified, confirmed, and ratified prior to closing. And then we either prorate them or the seller pays them in full. So just know that if you check box B, your seller is going to pay off the sewer improvement prior to closing, or whatever it is, the water improvements in Cape Coral. But also be very careful of this. For example, if you're on Marco Island and you've got the Marco Island sewer assessment, it is required by law to be paid at closing, at the transfer. So whichever box you check, it's still getting paid. Okay. Then they've got the, this does not apply to special taxing benefits or CDDs. Okay, now we get into our disclosures. So we've got our radon gas disclosure. It's naturally occurring. Everybody knows about radon, and we don't really worry about it unless we're selling a condo and we want to get a credit. That's a joke. If you have radon, you certainly can deal with it. But in this contract, there is not a radon inspection. So be very careful about that. There's not a specific radon inspection in this contract. You have to disclose open permits. If the seller identifies permits which have not been closed or which were not permitted, then the seller has to deliver all of the plans and everything in their possession to the buyer so the buyer can deal with the open permits. If you can get a mold inspection under this contract. It requires an addendum. There is a new mold addendum. So just know, this is just the disclosure to tell buyers that it's naturally occurring. You got your flood zone disclosure. Now in this contract, if the property is in a flood zone and it's not eligible for flood insurance, then the buyer can terminate, but it's within 20 days of the effective date. So hear me on this one, it's very important. If you have to be within 20 days of the effective date to terminate if you can't get flood insurance. What does that mean? Similar to having to deal with your lender up front, you need to deal with your insurance up front. The buyer needs to examine the property for insurance issues up front before they go to contract, so they know whether they're going to get their flood and their homeowner's insurance. Then you've got your energy, your lead-based paint, your association disclosure. So different from NABOR, this contract requires riders for association disclosures. And we'll talk about that when we get to the riders, but just be very aware that if you're selling in an HOA or you're selling a condominium, you have to attach the appropriate rider A or B to this contract. It's not included like it is in the NABOR contract. Excuse me. Your property tax disclosure summary. Then you've got your FERPTA disclosure, which I do a whole class on FERPTA. but essentially the seller may need to bring cash to closing to cover FERPTA. That's important. And then your seller's Johnson v. Davis disclosure. Seller knows of no facts materially affecting the value of the real property which are not readily observable and which have not been disclosed to buyer. Everybody here should know about Johnson v. Davis. Johnson versus Davis is a case that says the buyer cannot hide things that they know are wrong with the property. The subsequent case law on that says that the realtor cannot hide things that they know are wrong with the property. So if you get information that your seller is, for example, painting over the mold or hiding a water leak during the dry season, you as the realtor are obligated to disclose that to the buyer if you're the listing agent. And if you don't, you could be sued separately from the seller. So be very careful about that. And remember, you're the one with the insurance. You've got an E&O policy that they can go after, which makes you a ripe target for a lawsuit. So you got to protect yourself. Mattia is asking, for example, the Benitez about assessments. Mattia, yeah, that you would disclose that. Or it's on the tax. If it's on the tax bill, then you can provide the tax bill. Okay, so let's talk about property maintenance and inspections. A few changes to property maintenance and inspections.
No, it's helpful to me, but
Yes, Jennifer?
I'm not gonna.
Jennifer, do you have a question? Okay, property maintenance and inspections. So except for ordinary wear and tear and casualty loss, the seller needs to maintain the property, including the lawn, pool, and shrubbery in the condition it existed on the effective date. What does that mean? That means that on the effective date, when everybody signs the contract, then essentially the property is frozen in time, and that's the way it should look at closing, except for wear and tear or any casualty loss, which would be like a hurricane or a fire. So in the inspection period, and you set that up here, how many days the buyer has to do their inspections. They can complete the 3 inspections we talked about earlier, the general, the WDO, and the permit inspections. Those inspections are defined here in section 12, and they are very detailed, and we're going to go through them. Note here, though, that the seller has to have paid receipts for all work done. This is different than neighbor. Let's talk about. Yes,
Sam,
Steve. Yes, Steve.
I had a cash buyer, excuse me, that waived all the inspection. But when they came to buy insurance, the insurance company said if they get a wind mitigation and 4-point inspection, they can get a discount.
Right.
So my question is, I understand that they have a right to do wind mitigation, but if you have waived at the time that market was too hot, now say the roof is wrong, something definitely wrong, or the plumbing is falling apart. I'm just saying as an example. And you are representing the sellers. Can that deal fall apart if, because of buying insurance, a cash buyer is rejecting to buy an insurance that they do not require wind mitigation?
No, I would say the deal would not fall apart, and the buyer would be in default if they tried to terminate.
Okay, I
Because-
wasn't sure how that works, because if you have waived it and you are the seller, and now you come and say, oh, they're doing a 4-point inspection, they are doing a wind, it's kind of difficult for my understanding. I didn't know what is that, but I didn't make a fool out of myself. So I just called another insurance company, say the only reason they were doing that to get a discount. And I knew the house was well maintained, so I wasn't worried. But then on the other hand, you have to know the answer when you're representing the seller. And at that
Well,
moment,
the answer is very simple. The buyer waived their inspections by either putting 0 in this blank up here,
correct. Correct.
or by saying they're not going to do inspections in writing, and they
Correct.
wouldn't have any option. So they may be upset about the wind mitt, but
Right.
there's nothing they can do about it.
Okay, so they are contractually obligated to carry through
Yes.
by contract.
Yep.
Okay, they wouldn't find any other episode saying that we
Well,
cannot.
there could be other provisions. There may be other issues with titling and things. It's not 100% perfect, but on this specific issue,
Right.
the buyer would have to move forward.
Okay, thank you
Yep.
so much.
You're welcome. Okay. Nanette is asking, since going under contract, a large palm tree on the property is diseased and has to be removed. A new tree cannot be replaced in that same spot due to the disease. Does the seller owe the buyer a monetary value of the cost of the tree? I am not 100% certain on that, Nanette, because this contract says the property is to be maintained as is. And I don't think a tree disease counts as a casualty loss. What I would say is that that scenario was not covered here. And you're going to have to negotiate that out with the buyer and the seller. So going through the general property inspections, again, we said general WDO and permit, we typically do 15 days, although it can be less. General inspections must be done by a professional inspector. You must provide written notice, including a copy of the portion of the report that deal with the specific items when you notice the seller of the defects. This is different than NABOR again, because the NABOR requires you to file the complete report, whereas this only requires a portion of the report. And then this very detailed definition of property condition here. The following items shall be free of leaks, water damage, and structural damage. Then it lists out the ceiling, the roof, the walls, the doors, the windows, and the foundation. And then it says that those items, along with all of these listed items, must be in working condition. So your pool equipment, your major appliances, your heating, cooling, mechanical, electrical, security, sprinklers, all must be in working condition. So I'm going to skip down. What does working condition mean? It means operating in the manner in which this item was designed to operate. So if your screen door was supposed to slide close and it doesn't slide or it doesn't lock, or if the dishwasher tips forward because it's missing a screw, the little screw that goes in underneath the cabinet to hold the thing in place, those are not in working condition and have to be fixed. But note that torn screens, including pool and patio screens, fog windows, missing roof tiles, and shingles shall be repaired or replaced. This is also different than NABOR, which says the opposite. So in this contract, you have to disclose, you have to repair these items unless they're cosmetic conditions, which we define below as aesthetic imperfections that do not affect the working condition. And then they get specific with things like pitted marcite, that's your pool, tears, worn spots, and discolorations in floor coverings, wallpapers, windows, treatments, nail holes, scrapes, scratches, dents. All these are little things that have to be fixed or do not have to be fixed because they're cosmetic conditions.
Hey, Sam?
Yes, Dan.
Yeah, this is Dan. So a fogged window, in my opinion, is a cosmetic condition.
Not in this contract.
No, not in that contract, but the window works properly, goes up and down, stays, but it
Yep.
doesn't matter, huh, in this contract?
If
Okay,
it's fogged over, that means the seal is broken, moisture is getting in there, and it's got to be replaced probably. Usually, I don't think you can repair those gas-filled windows. Now, this contract says that cracked roof tiles, curling or worn shingles, or limited roof life shall not be defect so long as there is no evidence of actual leaks, leakage, or structural damage. I did look up leakage because I wasn't sure what that word meant as opposed to leaks. And basically, leaks and leakage are the same thing. So if your roof does not leak and it's structurally sound, then cracked tiles and curling or worn shingles do not have to be fixed. But notice up here again, missing tiles in this contract have to be replaced. So they got to know, is it cracked or is it missing? Pay attention, you got to pay attention to that, and you got to get a good roof inspection. Okay. So how do we make these repairs for the general? And I'm going to be very careful when I talk about this, because WDO and permits are all, and general are all treated differently in this contract. So for general repairs, seller within 10 days after receipt of the buyer's notice and inspection report either completes the repairs or gets them estimated by an appropriately licensed person and talks to the buyer about what has to be done. If there is a dispute, this is a nice part of this contract. If the buyer comes in and says, the sprinkler system doesn't work right, and the seller comes back and says, no, the sprinkler system works fine, you don't know what you're doing, then the buyer and seller split the cost of a third inspector, who then comes in and makes a definitive response as to whether the sprinkler system is correctly working, and that report is binding on the parties, and then the repairs are made or not made based on that third-party report. Excuse me again. Leslie says wells are not addressed in the general property repairs. If you've got a well on the property, Leslie, we should write in special language to get that inspected. Okay. If the cost to repair general repair items equal or less than the repair limit, then the seller just makes the repairs up to the 1.5% or the $7,500 or whatever you've agreed to. Now, this is where it gets interesting in this contract. If the repairs exceed the limit, then either the seller or the buyer have to take action, or the contract can be terminated by either party. So say you've got that repair limit at 1.5% on a $500,000 property, and you're up to $7,500 for your repair limit, and then the repairs come in at $10,000 for a new air conditioner. The air conditioner is kaput, and by the way, this says replace, cost to repair or replace. So if you've got to replace the air conditioner up to $7,500, it's going to cost $10,000, then either the seller can elect to pay the excess, or the buyer can elect to take the $7,500 only. If neither party delivers notice, then either party can terminate within the 10-day period. So, or within 5 days after the last estimate. So you've got to be careful in this contract about when you can terminate. If your seller says, I'm not fixing $10,000 worth of air conditioning, I'll only do $7,500, that gives the buyer an out. So you got to be very careful there. Everybody understand that? Any questions about general repairs? Because I know it's a lot of back and forth. Okay. Darian says, with labor and supply chain issues, what if the seller can't get the item repaired before the contract is due to expire? If you go to the closing date and the repairs are not done, Darian, then you escrow 125% of the cost of the repair, but only up to the repair limit. And then that goes into escrow, and you can complete the repairs after closing. Okay, wood destroying organisms. If you've got a WDO, you do the inspections. If they discover WDO that has been previously treated, then the seller does not have to retreat. They provide their full warranty. Again, if you find WDO and you have to do a repair, then the buyer can deliver notice to the seller agreeing to repair the excess, or designate which WDO repairs the seller shall make. Excuse me. If the buyer doesn't make their election, then either party can terminate. So you make sure your buyer makes their WDO election if they find WDO issues. Okay, Closing out of building permits. This gets a little hairy as well. You get to examine all the records and the documents. The seller has to deliver all of the plans and documentation they have for the permits. Excuse me, gosh. If there is open permits that have not been satisfied by the closing date, this provision gives an extension for up to 10 days to complete final inspections. And if the inspections are not completed at 10 days after closing, or I'm sorry, after the extension, then the buyer can get their money back again. So you got to be very careful here about getting these permits closed out as quickly as possible and get the county inspectors over there as quickly as possible. What I always suggest as a solution to open permits, because Cindy, I see your question about lenders don't allow holdbacks for things. Get the permit, have your favorite closing agent review the permit history before you go to contract. And it's very easy now, it's pretty much all online. I can go back pretty far. There's 2 different websites in Collier County that you go to. But you can go back pretty far. You can call the county, you can do a permit inspection prior to contracting, because you don't want to terminate for something as silly as like a 25-year-old open permit. So I always suggest to sellers that they get their permits resolved prior to contracting. Okay, questions about these before I move on to the rest of this? Questions about WDO permits?
You
Or
mentioned the one,
general?
you have the 125% escrow holdback scenario, and if the lender doesn't allow that, what are we doing?
If this lender won't allow it, then you're going to have a problem. You either have to do it somehow, do a separate. If they won't allow like an escrow holdback, I'm not actually seeing where lenders won't allow an escrow off the closing statement. Usually they won't allow credits, but we typically, because these come up on the closing date, they typically don't make it onto the closing statement. If the lender says no, then you may have a property related condition that wasn't fulfilled and the buyer would terminate. Hopefully that doesn't happen. I have to look at the specifics of that, Cindy.
Sam, Jason here. Can you explain again if it exceeds that 1.5% limit?
So first, don't get hung up on 1.5%, because if you're selling $1 million property, you're not going to want $15,000 in repair limit. So just the repair limit, if it exceeds that for any one of these, then you've got to review the specific provision. But for general, then the seller goes up to the repair limit for their costs, or the seller can elect to repair more than that, or the buyer can elect to take as is with up to the limit, or either party can terminate. For WDO, again, the seller can agree to pay the excess, or the buyer can designate exactly what they want to be repaired. And if they don't do that, then either party can terminate. For permits, if the if the permits are not closed out by closing, then you get a 10-day extension to complete final inspections. You can receive a credit up to, the buyer can receive a credit up to the repair limit and take the property as is. Okay. All right, so the walkthrough inspection on the day prior to the closing date or on the closing date itself, the buyer can do their walkthrough, and it can be the buyer or the buyer's representative. Now, you are a buyer's representative. I do not recommend that you be the representative who does the walkthrough. Do a FaceTime with the buyer, do a recorded Zoom call would be better, so you have it recorded. But don't be the one, I'm sure your brokers will agree with me, don't be the one who does the walkthrough and misses something for the buyer and then has the buyer come back to you and say, why did we close when the air conditioner doesn't work or something like that. So be very cautious about being the person who does the walkthrough for the buyer. You don't want to be that person. And then all work must be done in a good and workmanlike manner. by appropriately licensed persons. So you cannot have Uncle Bob come over and fix all the light switches. Appropriately licensed persons must make all repairs. Okay, that's inspections in the FAR bar contract. Any questions about that? Okay. Moving right along. Escrow agent and broker, this is mostly for me, but basically the funds are subject to collection. So I don't have to close the contract until the funds are collected. Again, that means wires for closing. We don't take checks. Nobody takes checks anymore. And if you do try to use a check, the buyer's going to be in default and they're going to lose their deposit. Okay. This just says that if we do have an escrow dispute, then the closing agent gets their attorney's fees paid. Notice this provision here. This is a big liability protection for you and your broker. You are not warranting the condition of the property, and you agree, and the buyer and seller agree to indemnify the brokers and the realtors. This is for your protection. Okay, if there is a default, what happens when the contract doesn't go through? The seller can keep the deposit as liquidated damages, or the seller can proceed in equity. That means sue for specific performance under the contract. So for those of you that are used to neighbor, again, very different, where the seller only gets deposits made. Here, the seller gets all deposits, or they can sue for specific performance. If the seller defaults, then the buyer can sue for specific performance or get damages. Now, this contract has a little different than other contracts in that it also says that if there is a dispute over the deposit, you go to mediation. And you have 10 days after the dispute comes to fruition, after the conflicting demands are made for the deposits, to get into mediation, and you have to hire an experienced mediator. At that point, lawyers should be involved. Yeah, the winner in any dispute gets their attorney's fees paid. So note that it's not a slam dunk, but it is in the contract that attorney's fees are paid by the winner of the lawsuit. That's usually a cudgel that you can use to beat the other party into submission, that they will be paying attorney's fees. If they lose, they should not go to litigation in this.
Sam, I have a question. It's Linda
Yes,
Schmidt.
Linda.
How are you? I have a question regarding the seller keeping all of those deposits. Now, you're talking about the one that's due within 3 days and the additional deposit, but that does not include the balance to close if you're paying cash, right? Or getting
That's
a
right. That's right.
It does not include.
It does not include the balance to close, just the deposits.
Okay, thank you. That was it.
Okay. So now we're going to get into the standards for closing. You've got your title standards, these are mostly for me to deal with as the closing agent, but the property has to be used for residential purposes. If there is a title defect, you can extend the contract for up to 120 days. People don't, or more, or I'm sorry, 150 days, because you get 30 days plus an additional 120, your extended cure period. So be very careful here. If you've got title defects, you may not have a closing, and you may need to deal with loan rate lock extensions, and who's going to pay for those rate lock extensions and how that's going to work. So you'll be negotiating that if there's a title defect. We talked about surveys. The buyer has 5 days to examine the survey and get their objections to the seller, which are treated like title defects. Okay, the seller agrees that there's ingress and egress. That's the right of access to the property. Every property in Florida has a right of access to the nearest public road. We talked about leases, but at least 10 days prior to closing, the seller's got to provide the estoppel letters. That's the lease, the tenant signed estoppel letter that tells what the actual deal is with the tenant. And if the buyer doesn't like what the estoppel letter says when compared to the lease, then the buyer can terminate. So you've got to be careful to make sure your tenant estoppels are in early and they comply with the lease requirements. Otherwise, your buyer gets a right to terminate, and that can be close to closing. Okay, liens, there'll be affidavits signed at closing to deal with liens. Okay, time is of the essence in this contract. Very important provision in the FARBAR contract. All deadlines are time of the essence. You cannot be late on your deposit. For those of you that like the NABOR contract, because you can be late on things, you cannot be late in this contract on your deposits. If you are late on your first deposit, the contract terminates and you owe both deposits. That's how default works in this contract. So be very careful there to make sure that the deposits are done on time. Calendar days are used in this contract. So it's calendar days, not business days. I get that question a lot. If the deadline falls on a Saturday, Sunday, or national public holiday, you extend to the next calendar day. And notice in here now, this contract does not say 5 p.m. anymore. So for those of you that are used to the old version 5 contract, where it was till 5 p.m. on the next calendar day, it now goes till 11:59. Everybody understand that? 11:59, not 5 o'clock. Okay, force majeure. So if you have a force majeure, which is a hurricane, flood, extreme weather, act of God, epidemic, or pandemic, then the non-performing party gets up to 7 days after the non-performance is once they can perform, they have 7 days, but not more than 30 to complete the contract. And by the way, really important, there was a case that just came out that says pandemics are not force majeure events, even though it says it in this contract that they are, because you can perform. So using Zoom, using DocuSign, using remote online notaries, it will be very hard to claim COVID as a reason for not performing under this contract, even though there is a pandemic presently going on. Okay, the seller's got to convey marketable title at closing. That's pretty obvious, I think, for most people, although I am in the middle of a dispute with another attorney who doesn't understand what marketable title is. So I sent him a 1,000-page treatise on marketable title so we can brush up on it. Marketable title is a title that you can resell. Just know that. If you can resell it, it's marketable. The closing occurs in the county where the real property is located or at such other location agreed by the parties. Sometimes we get into disputes with Miami title companies that wanted the closing in Miami when the property is in Fort Myers. That can be a no-no under this contract. The closing documents have to be signed and delivered into closing prior to closing. And again, the seller has to provide the paid receipts for all work done. Don't forget your paid receipts. Fincen GTO reporting obligations. So for Naples, for Collier and Lee counties, this is not applicable, but for Broward, Dade, and Palm Beach counties, there's special reporting requirements to the U.S. Treasury Department Financial Crimes Enforcement Network. Get with me separately on that if you have any questions about GTO reporting, but basically, I have to know who the human being doing the transaction is. Can't deal with the LLC, can't deal with the trust, can't deal with the foreign entity. It's got to be the human being. Okay, we record the deed at closing. That's obvious. Prorations. We prorate the real estate taxes. We prorate the assessments. We prorate the association fees, the rents. And the buyer shall have the option of taking over assumable insurance policies. So the seller has to provide that information to make that happen. Access to the property. We talked about this earlier, appraisals, inspections, including the walkthrough. You have to provide utility service and access. You can't shut the water off a day early. If there is a loss that exceeds 1.5% of the purchase price, essentially there won't be a closing unless they agree otherwise. If there is going to be a 1031 exchange, I love this. Realtors, you guys love to put in your contracts, buyer is doing a 1031 exchange. And I appreciate that, but you don't have to do that. It's already in the contract, FAR/BAR and NABOR, but right here, if there's a 1031 exchange, the parties agree to cooperate. The contract is not recordable. I've had that question. If your seller dies in the middle of your transaction, which this happens a lot in Southwest Florida, the heirs, successors in interest continue the contract and the buyer has a right to buy the property. Okay, all notices must be in writing, only made by mail, fax transmission, personal delivery, or email. Hear me on this, no text messages. You cannot give notice by text message anymore in this contract. And for those of you that like the NABOR forms, that's going to be the same in the NABOR form when the new one comes out next year. No more texting. It's too dangerous. Too many things get lost in translation. Things don't get recorded properly. No more texting. Everybody got that? I see a few heads shaking. No more texting. Integration. This is very important as well. The MLS listing sheet, unless you specifically attach it to this contract, it does not mean if something is listed in the MLS as conveying, but you fail to write it on page 1 of the contract, it's not included. The buyer doesn't get it. So this contract contains the fully complete understanding and agreement of the buyer and the seller with respect to the transaction. That means that all the emails, all the conversation about furniture and financing, if it's not in this document, it doesn't count. And then you've got your FERPTA information here. I do a whole class on FERPTA, so I won't get into it too much here. Now, if you don't check the box, then the question is whether your rider that you attach is a part of the contract. I submit to you that it would be, but don't forget to check the box. Then you've got your additional terms. If you're going to put anything in here, please get it blessed by a lawyer. Don't have me look at this. Don't just write things into the additional terms. Otherwise, that's unlicensed practice of law. I'm happy to do it. I don't charge for it.
Quick question on the check
Yes,
boxes.
Cindy.
Lead-based paint, quite often they are not completed by the seller ahead of time. So they signed the 12 pages today for everything being agreed to, but they did not get the lead-based paint until 2 days from now. What does that do to the effective date?
It becomes an amendment. If you sign afterwards, it does not change the effective date.
Okay.
Okay, that takes us to the end of this contract. And now we're going to talk very briefly about a couple of riders that I think are important. I'm not going to go through all of the riders. There are about 30 of them. Note that if you have an interest in the transaction, you have to disclose that. Special taxing district disclosure, that's pretty basic. Okay, very important is the condominium rider. We'll talk about the condo and the HOA rider. The condominium rider is rider A. You check whether association approval is or is not required. Then if there's a right of first refusal, you put that here. Of course, a right of first refusal is where the association can buy the property out from under the buyer. That prevents lowball offers. Then on this contract, very different than NABOR, you actually put your condominium assessments in these blanks and you fill in the period for when they're payable. Note, this is not required by law, but we do it in the FAR/BAR contract, different than the NABOR contract. So make sure you know your association information. If you're the selling agent, you've got your buyer. prior to making your offer so you can properly fill this in. You should work with your listing agent to get that information because, where is it? Where is it? Somewhere in here, it says that the seller shall initiate the process for getting the association. I'm sorry, I apologize, I thought I had highlighted. So your seller needs to initiate the process and get the condo application to the buyer. What I suggest that folks do when you're selling condominiums is put your association documents in a PDF and put them in the MLS. Then you can get the condo doc receipt, or in this contract, you can just check this box right here. Buyer acknowledges that they have received the documents, and you don't get a waiver of the 3-day requirement after the contract is signed for condos, but you can at least have acknowledgement right in your contract that your buyer already received the documents. So that's a big deal, I think. And then you've got your
Sam?
Yes.
So, because the thing about that one, it says that they received it more than 3 days prior to the execution of the contract, which
I
most
see
often
that.
they don't have it. So you wouldn't check that, right? Because usually you're
Right.
seeing
Most
it
of the
with,
time you would check box B. That's right.
okay, but then when you go a little bit lower, I just had one other question, because on number 7, it says they received the documents as defined in paragraph 5, but they didn't receive it 3 days prior. They received it on the day that they signed the offer, not necessarily the executed date, because the seller didn't sign yet. So if you
Right.
get to
And that's
7,
why in section 7, it says you only complete and check if it's correct. So you would leave this blank if it was not correct.
and so then would you in number 6 say you have to check one there? So you're not really requesting it because you have it, but
Yeah, this is not the most perfect form,
okay,
but you got to muddle your way through it.
okay,
If the buyer wants the documents, you would check this box for requests. If they do not want, check this box. And then if they are already received, you would check this box down here. And I agree, this could be cleaned up. But again, the FAR bar is much different, the way they do things for making changes. That's why it took them many years to make one change to this document. You list your your parking, your garage, or if you have a boat slip, all that goes here. And then this is an admonishment. If there's a leaking roof in the condominium, the seller's not obligated to repair that because it's a common element. If it's affecting their property, their unit, then they would fix what's in their unit, and they'd have to work with the association to get that done. And that can be a very difficult situation. We have a lot of that. Okay, rider B is for homeowner associations. Again, this first section, I'm going to zoom out here so you can see the whole thing. This first section right here, all of this is cut and paste from the statute. This does not change. If you fill these blanks out incorrectly here, then you are giving your buyer an automatic out because you do not convey the correct statutory information. And there's a case that says if you're off by a penny, then the buyer can terminate. So get these numbers and time periods correct in these boxes. You've got these boxes. If there's a special assessment, it goes here. Again, the period of the special assessment goes here. And if you've got recreational leases, it goes here. Here it is. Okay, they didn't have it in the condo one. The seller shall initiate the approval process. So the seller needs to get the approval or get the application over to the buyer. And then down here, you've got your payment of fees. So if they're, put your master association, your local association, your country club. If you're in Vanderbilt, you've got 8 different association fees that you got to pay, including your food and beverage. You would need a separate piece of paper for all of that. But in the FAR contract, you can list all those here, and makes it very easy to disclose to the buyer what their fees are going to be. Okay, binding arbitration. If you want to go to arbitration instead of litigate, you can use that. Nobody does that though. Seller financing. Again, if you've got seller financing, then call me. We'll walk through this. Very confusing, but these are the only options available for seller financing. New law under Dodd-Frank, you can't do a 1-year ARM with seller financing anymore. So you put your purchase money, whether it's going to be a first or a second, the principal amount of the loan, the interest rate, again, your payment terms, you pick one of these. Typically, you would do a balloon mortgage up to 5, it's got to be 5 years or more. And then you've got your principal plus your interest and your payments down here. And then your terms, they're typically no prepayment penalty is allowed in this contract, and insurance has got to be maintained by the buyer. If you're going to assume a mortgage, you've got this rider. Again, I don't think lenders are going to allow this because they want the higher interest rate, but you can try. Seasonal rentals. This is a new form as well. The buyer can approve or not approve new seasonal rentals. And unless the contract is terminated, the buyer agrees to use the seller's management company until all the seasonal rentals that the seller had in place are up. So be careful there. Your buyer may not like the property manager, but they may be stuck with it. Okay, I'm going to skip through. This is the VA FHA financing. If you do that, you must use this form properly filled in. PACE loans. PACE loans are disfavored now, so we don't deal with those anymore. If you're going to do a cash deal and you want an appraisal, you've got to use the appraisal contingency. The appraisal contingency form is very simple. You have so many days, 10 days, unless you put more, to get the property appraised for a certain value. If you don't fill it in, then the purchase price is the default. Seeing a lot of appraisals. Okay, we don't do short sales anymore, so I'm going to skip through that one. Hopefully we won't go back to short sales for those of you that have been around a while. Flood insurance. If you're going to if the buyer is unable to obtain flood insurance, you can use this, and you can go through Citizens. That's going to become more and more of an issue. I'm actually going to start taking classes on insurance, and then I'll provide some information in my title tips emails. You can get a mold inspection. Use addendum I. This is a new rider for mold. If the property is going to be converted to an as-is, you can just use the as-is contract, or you can use this rider. I would suggest using the as-is contract. Right to inspect, right to cancel is the Marie Antoinette addendum, because you can have your cake and eat it too. You can get repairs, or you can terminate if you don't like the way the property looks after inspections. Again, it's 15 days to get your inspections done and then terminate. We don't really do defective drywall anymore. If you sell on the shore side, on the water side of the coastal construction control line, call me, because there's a couple of extra things that we have to deal with regard to surveys. If you've got housings for older person, you need to use this rider. That's similar to Neighbor, where you've got the rider for housing for older persons. Yes, you have to include it, Batya. You must, if you want a mold inspection, you need the rider. Okay, pre-closing occupancy, this was asked about earlier. If you've got to do a pre-closing occupancy, then you'll use this form. This form contemplates some type of lease or pre-closing occupancy agreement, a separate writing. So you need, I can prepare that for you. I've got those forms that I've made. Again, for post-closing, same thing, some type of agreement in addition to this form. That's different than NABOR, which provides the actual agreement in an addendum or an amendment. If the buyer is going to sell their property, then you have to use this rider, and you need to check whether it is or is not under contract, and you need to fill in the address. That should be all of them. All right, with that, does anybody have additional questions? Can I go back over anything?
Bob has a question.
Yes, Bob.
If the buyer wants to terminate the contract and release of escrow funds, and the other party doesn't sign the release of escrow funds, what happens?
If the buyer wants their escrow back and they have a legitimate reason to receive it back and the seller refuses to sign, then the buyer could sue the seller to release the deposit, or the title company. Again, we've got those conflicting demands. Then there could be a mediation followed by a lawsuit, and the attorney's fees would be paid by the
Winner.
loser. So the seller would be not smart if the buyer had a legitimate reason to terminate. If the buyer's just trying to get their money back and the seller says you don't have a legitimate reason to terminate, then I wouldn't sign that, and I would say sue me.
I had a question, Maria
Yes,
Gaviria.
Maria.
When buyer and sellers had a dispute for the escrow, the property can be back to the MLS or the?
Very good question. So I take an aggressive position on this. If the buyer misses a deadline, for example, and the contract terminates because time is of the essence, I would tell my listing agent to relist the property and get it sold. If the buyer wants to fight about it and they think they've got a legitimate claim, they can sue the seller, put a list pendens on the property, and then they can run the risk of being sued for slander of title if they're wrong. So there's back and forth both ways on that. But if I've got the seller, and the buyer walks for whatever reason, I tell the listing agent, go ahead and get it back listed. Okay, we got some questions in the chat. Kay is asking, where do we get the version 6 documents? Kay, version 6 documents are in all the forms folders. As a matter of fact, you can't get version 5 anymore. So form simplicity, zip forms, all those are loaded with version 6 now.
Sam, I have a question.
Yes, Tina.
If a buyer agent doesn't want to come walk through and tells me, that's the listing agent, we are not coming to walk through, and the seller has never seen the house, the buyer agent only showed him on FaceTime, is the listing agent in any kind of shape or form any liability closing tomorrow?
If the buyer refuses to do a walkthrough and the selling agent doesn't want to do it for the buyer, is the listing agent liable? No.
Yeah.
No,
Okay.
I don't see where they would be liable for anything.
Okay,
It's on the buyer.
yeah, the buyer agent texts me and not email me that he doesn't want to do a walkthrough for the buyers. The buyer, one of the buyer of the 3 is gonna be there and asking me to put the code for the garage after closing. So they just go in and pick up their key. I just want to make sure that it is not creating any trouble on listing side, seller side, that nobody.
No, if the buyer would, for example, were to waive their walkthrough and then they come to the property after closing when they own it and the air conditioning didn't work, that would be entirely the buyer's problem for failing to do a walkthrough.
But it is he said and she said because they didn't put it in writing. The agent is texting me that he's not doing a walkthrough. He's coming in to visit them following week when they are all here. But meanwhile,
The property is closed. See, what happens when the closing occurs,
Yeah,
the contract goes away and it
Okay, good.
merges into the deed. So the
Good.
buyer would be stuck with whatever condition the property was.
I swear to God, Sal, I'm 22 years in the business. Every once in a while, I get these weirdest requests or things like that, you know, and I don't know what the answers are other than when I.
Call me. The answer is always give me a call.
Thanks again. Thank
All
you
right.
so much.
Sam, I have a
Yes,
question. Oh, go ahead.
Linda.
On the condo association rider, community association rider, when it comes to assessments that are voted on prior to, because I think we skipped over that, prior to us signing a contract. I just want to make sure, you know, because normally I put seller shall pay assessments in full prior to closing. That's further down.
So special assessments, I did skip that. I apologize. Thank you for asking. Seller represents that the seller is not aware of any special assessments other than what is listed here. And look what's got to be done. In this contract, different than NABOR, if it's been on the agenda or reported in the minutes of the association within the previous 12 months, then it's a pending assessment that needs to be disclosed and dealt with.
Which is why when I list, I make sure that they give me that when I list so that I can't say that something comes up down the line, because sometimes the sellers don't go to the meetings and pay attention.
Yes,
Right, they have no
I
clue.
always tell the realtors that I work with, you've got to know your associations. You've got to know the communities that you're dealing with. Okay, I have a question in the chat. Hold on. Can a listing agent make you use this contract instead of the FAR bar as is? James, the seller is under no obligation to accept any offer. So if the seller says, I want a regular FAR bar contract instead of an as is, they absolutely can do that. You don't have to make an offer. You can make an offer on an as is and have it rejected. They can make a counter offer on this form, but there's no obligation to use a particular form or accept a form that you don't like. Rebecca is asking, if a seller now tenant required a post-closing occupancy, you do not need a post-closing occupancy for a tenant, Rebecca, because the tenancy merges into the deed, similar to the doctrine of merger for the contract. All right, we went way over time. I'd like to keep these to an hour, and it's been 2 hours. Does anybody have any final questions? Anybody? Okay. Thank you,
Thank
everybody. I
you.
really appreciate it. You guys are awesome. Call me, text, email with any questions. I'll be sending out the slides shortly.
Hey,
Thank
thanks.
you. Have a
Thank
fun
you.
day.
Thank you.
All right.
Thanks.